Halsbury's Law 2011 states that administration courts have no authority. The Clearfield Doctrine is when government bodies take the corporate paper script, commonly known as 5, 10, 20 and £50 notes, and clearly state upon those notes that they are each a denomination of fiat currency, known as, and stated upon them, all in very small writing, that they are a promissory note, meaning when used to purchase something, you are only promising to pay for your purchases and never actually paid for your goods. When this happens within an administrative court, they lose their governing status and lower themselves to the same status as any other corporate entity. Therefore, administration courts answer to legislation and require both a contract and consent from yourself. Without them, there is no joinder and technically no jurisdiction. This is what this arbitration court is all about. And it might be worth noting that what you're about to see now may well be the very first arbitration court independent of state jurisdiction.
Right, welcome everyone. I'd like to say thank you for all that's come here. It took the time out in their day to be here to witness a lawful court of the people, for the people, by the people. This is a lawful declaration of standing. This is a final arbitration statement and also an enforcement and recovery order. So my declaration of a living man, I, a man, Darren-Watt of the House of Smith, a living man of sound mind and body, hereby affirm and declare before witnesses and by public record that I am a living soul, authorised representative, executor and beneficiary and secure party creditor of the estate known by the legal fiction or caps name, that I stand under natural law, natural common law, contract law, universal commercial code and the uniform bonding code, that I have evoked my lawful rights under just in rem, nemo duat quod nom habet, do apologise for my pronunciations on that, ex dealo malo non orita actio, as stated in my verbal testimony, that my unrebutted affidavits, notices, lawful demands stands as established facts in law and equity, that I do not consent nor submit to corporate, statutory or maritime jurisdiction by presumption or adhesion contracts, and I rebut all such claims, that I have issued lawful notices, liens, writs, arbitration invitations in good faith, all unrebutted and lawfully binding, establishing procedure of dishonour and default by all opposing parties, that I reserve all rights and remedies under the UCC 1-308 and the UCC 1-103 and other foundational legal and lawful principles referenced herein, that I produce and proceed in good faith, honour and equity, seeking remedy under lawful and natural justice, that I hold all parties trespassing upon my rights, personally and commercially, liable and subjected to full recruitment, lien enforcement and lawful remedy. This lawful declaration of standing. As the executor and beneficiary, living man on the land, non-combative secure party creditor, again under the UCC 1-308 Uniform Bonding Code and just in rem jurisdiction. So the declaration of the jurisdiction, as no lawful contract exists, no lawful signature binds the man, Darren Watt of the House of Smith, to any alleged debt or obligation, and no court has proven valid jurisdiction within competent evidence. This court is convened in the private, outside corporate fiction's jurisdiction. This proceeding occurs due to failed to rebut multiple sworn affidavits, failure to produce valid contracts, refusal to present lawful authority and standing, failure of statutory courts to deliver remedy, acting under the colour of law and the colour of jurisdictions. I'd just like also to say, I'm here to make remedy, as I have done from day one. The remedy is to the controversy that the bank has brought forth. I'm an honourable man, and I swear by that on the law that I stand under and under God's law. I've always been openly and transparent that if I have done a harm, wrong or injury, then I will then honour that by remedy, and I would admit to that harm, wrong and injury. I'm happy to make that remedy with an open heart, with truth and facts. To this day, that has not been done. The evidence has not been brought forward, the victim hasn't come forward, nor is there an affidavit of statement of truth from that victim to make their claim. It's all from a legal corporate fiction. I there yield my stance and to let the clerk of the court make their opening statement.
But before we go to Gary making his opening statement, let me introduce you to Darren whose arbitration court this matter is about. But first, before you start watching this video, it's important to understand what Darren has to say now in the next 4 minutes will help comprehend the nature of this video.
Alright, just a short video just to let you know the reasons why I went down the route of an arbitration court. So I just want you all to know that people have every right to hold your own private arbitration court. And I shall inform you the laws that allow this to happen. People need to understand that every living man and woman on this land have rights under natural common law of the land to seek fair justice. When all fails in their legislative corporate courts, these have been compromised massively. They're not law courts anymore. They're corporate legislative for business. They're for profit only. Okay, so let it be clear, and I entered into the public record. I have lawfully convened a private arbitration court. Now some might question its fidelity. Allow me to explain simply and precisely why it stands in law and cannot be dismissed. So first, the Arbitration Act of 1996 is a statute of Parliament. Provides the lawful right for any dispute to resolve by private arbitration when one party has offered and the other has failed to rebut. Right, so under the sections 6, 46 and 58 of this Act confirm that an arbitration award has the same force as a judgment from a high court. Let that sink in. Second, consent through silence. We hear this all the time. Acquiescence, you don't reply. I lawfully invited the bank Santander to select an arbitrator. They refused and ignored the invitation, and in commercial law, silence is dishonour. Not only dishonour, but no response is a tacit agreement. By failing to rebut and participate, they gave me full right to proceed. Thirdly, binding award. My arbitration award now stands in law. It is binding, final, and it's enforceable. Not only in this country under the Arbitration Act of 1996, but internationally under the New York Convention on the Recognitions of Arbitral Awards, 1956, in which the UK is a signatory. So fourth, higher than an administration court. Let that one sink in too. These courts now, the courts that seek to enforce alleged debts are administration, corporate venues, as I mentioned before. And they're operating under statutory presumptions, which we need to challenge at all times, because that's all they have is a presumption. So an arbitration, however, is private law, contract-based and recognised worldwide. It is therefore superior in substance and binding upon the corporate entities who are already bound by contracts and equity. So when Santander, the solicitors or any bank and even the judges say you cannot hold your own court, the answer is simple. I did, and it stands. This is not a matter of opinion. It really isn't not a matter of opinion. It is enshrined in statute, affirmed by international treaty and recognised both equity and commerce. My arbitration court was convened in honour, in truth, and full compliance of the law. Their refusal to attend is their dishonour. It was their choice. They've dishonour. Now the award stands unrebutted and it's enforceable. So I say, for the public record, justice has been served, not in an administrative chambers, but here in lawful arbitration court under the authority of the people and the law of the land. We all have this at our disposal. We should be using it.
Well, with the insight from Darren, this is now the proceedings from the arbitration court Darren has just explained about.
This arbitration court is convened by right of law under natural law, common law, law of contracts and Universal Commercial Code UCC under sections UC1-308 Reservations of Rights, UC1-103 Common Law Rights Preserved and UCC 1-201 General Definition of Standing. In accordance with the Uniform Bonding Code UBC sections 5356, 61 and 91, this lawful proceeding is convened following over 30 months of repeated dishonour, trespass, fraud and administrative malfeasance by the following: Santander Consumer UK PLC, Duns number 232663207, Company House number 005423336, DWF Law LLP, Duns number 217678161, Company House number 0C42384, HMCTS Administrative Court, Birmingham County Court at Derby, Duns 2210-92967, Ministry of Justice, Duns 234-824-660. The Arbitration Court convenes in full transparency, recorded for the public record, in response to the system refusal to answer lawful affidavits, conditional acceptances, notices of dishonour and final notice of enforcement. All parties are gathered in their private capacity under common law.
I, Terry Miles, in my lawful capacity as arbitrator, appointed under natural common law, law of contracts and international commercial law, hereby open this arbitration hearing, convened by lawful right and necessity. This hearing is convened in accordance with Universal Commercial Code UCC 1-103, 1-308 and 1-201. Uniform Bonding Code sections 5.3 through to 6.1. Principles of just in rem jurisdiction which pertain to rights in property and lawful title. The lawful right of any man or woman to seek remedy when all lawful avenues through administrative corporate courts have failed. International customary law, natural law and the Universal Declaration of Human Rights. The parties responsible for initiating these proceedings have evidenced through lawful notices, unrebutted affidavits, perfected commercial liens, and invitations to arbitration, a systematic failure by corporate agents and statutory courts to honour lawful obligations. As arbitrator, I swear to uphold impartiality, administer justice without favour or prejudice, and to ensure that the rights of the living claimant are fully recognised and protected in accordance with law, equity and fairness. Let this hearing be conducted with full transparency, recorded for the public record and standing in law as a court of record. Proceeding is now formally open.
Thank you. So my formal declaration, I shall state again. I, the man, Darren Watt of the House of Smith, affirm and declare I stand as a living man under the principles of natural law, free from any undisclosed contract, without joinder or submission by any corporate legal fiction. I am authorised representative, executor and beneficiary and secure party creditor of a constructive trust falsely attributed to the corporate fiction of the all caps name Mr. Darren Watt Smith. I have issued and perfected lawful unrebutted affidavits of truth with various dates: 24th of the 3rd 2003, the 11th of the 8th of 2003, 14th of the 2nd 2024, commercial liens registered and reference number DW-com-Echo November Foxtrot-001, and arbitration notices. And they were sent on from the 5th of the 4th 2025. In just in rem jurisdiction, law concerning property and rights upon it. The above parties are in violation of trust and fiduciary duties, failing to demonstrate proof of contract signed under full disclosure, proof of valid consideration, title and possession, proof of law, court, authority by wetting signatures and proper stamping as required under the CPR Civil Procedure Rules. Holder in due course states under the Bill of Exchange Act of 1882, and just for reference, holder in due course, the person who is the holder of due course can enforce alleged debt. If you're not the holder of due course, and the holder of due course is the owner of the original contract, if their holder of due course is not the holder of an original contract, then they cannot enforce a debt. To this day, the bank has failed to produce an original contract, but I shall go into that deeper. Fulfilment of fiduciary duties under Data Protection Act of 2018 and GDPR via DSAR's compliance. Their silence and procedure of dishonour activated estoppel and enforcements under common law maxims. Silence is acquiescence. He who leaves the battlefield first loses in default. As unrebutted affidavit stands as truth in commerce. For the public record and for lawful record, I, the man Darren Watt of the House of Smith, do hereby speak and declare that I am a living man under supreme law of the land, endowed by natural birth, with inalienable rights, no subject to corporate presumptions, not joined in any fiction contract, and not waiving any rights knowingly, voluntary, or intentionally. This arbitration court is convened under just in rem jurisdiction, as I hold lawful standing in right, superior to any and all claims arising from fictitious contracts or statutory constructs. The right in rem is absolute and enforceable against all, as it rises not from contract, but from natural standing. I stand firmly upon the maxims that fraud violates everything. The presence of fraud where administration or procedural cancels all presumptions of fidelity, ab initio, void from the beginning. I stand firmly upon the maxim, void vitiates everything. I remind all, presence of ex dolo, malo, non orita actio. No lawful action rises from fraud, and any judgment, orders or claims derived from deceit, coercion or admission are nullities in law and equity. Under notice to principal, to notice to agent, and notice to agent is notice to principal. All prior notices, affidavits, lawful demands served upon agents, clerks, solicitors and judiciary have been served upon the principal, and the dishonour is ignoring these notices is now absolute. I assert the timeless principles, equity will not suffer a wrong without remedy. The denial of lawful remedy by administration courts not to negate the existence of remedy at law, in equity and in natural justice, which this court is duty bound to enforce. I do not stand as surety as a debtor. I do not stand as a citizen or a corporate entity. I do not accept any presumption of joinder, and I rebut all adhesion to corporate contracts of which I have no full disclosure, no wet in signatures, and no equitable benefit. My unrebutted affidavits stand in truth of law in accordance with commercial maxims, UCC 1-308 and Uniform Bonding Codes. I have lawfully offered conditional acceptance to all claims which have been dishonoured and left unanswered, creating estoppel by acquiescence. Under ignoratio juris non execusat. No agent, solicitor or judge may claim ignorance of these rights or duties. I declare quod ab initio non violet in tractu temporis non complacit. What is void at the exception cannot be cured by time, and any unlawful claim or judgment, no matter how old, will always remain void, under the principle that no man is bound by the acts of another without his consent. I rebut any presumptions of corporate jurisdiction or enforcement upon my private estate. And for the record, I reserve all natural law, equity law, common law, contract law and commercial law rights, with all the power to enforce liens, collect damages and require specific performance under lawful remedy. Let this be known in the public record, under full personal liability of any man, woman, who may presume to trespass upon my lawful rights, under full international notice pursuant to the Uniform Bonding Code and international commercial standards. Right. Okay. Now I shall come with the evidence. The chronological summary of material facts. Since 2023, January to March, Santander alleged false claims without substantiating original agreements, conditional acceptance issued. I have notices here of conditional acceptance of the proof of claim, which is a maxim in law, that I have honourably and lawfully stated that if there is a controversy that I have to do, that I will make remedy with all my heart and under law. To this day, they haven't proven the burden. And the burden is that they have to prove that there's an original contract, signed and wet signatures. Secondly, that they have a consideration, that they offered a consideration part of that contract. To this day, they have not moved and proved that. And also losses, banking losses through their ledger. Again, they do not prove that whatsoever. What happens, in fact, I'll say that later. So here's a notice that has been sent, recorded delivery, and which has been received and signed for. As you can see, the first notice. And here's a receipt that it went through postal mechanics, that it was sent and paid for, and it was also received. They also received my second notice of default on opportunity to cure. Again, I'm staying in honour. I'm trying to make remedy. Prove the burden and I will gladly pay. To this date, we are not proven. Again, postal mechanics been signed and they've received this. A notice of default. Again, staying in honour, offering for remedy. All been refused, all been ignored. A notice of default and before an affidavit. Again, I'm giving them extra time. I did not need to send this, but I've sent it anyway because I'm staying in honour and I want to do the right thing. If I have caused someone harm, injury or a wrong or breached a contract, then I will make remedy and I will apologise. To this date, that has not been confirmed. Right, these other notices, when the solicitors took over from the bank to represent them, I sent the same things again to the solicitors. This is at a cost, but I wanted to do things in transparency and under law, and so it's recorded. Everything is recorded. Unlike the banks and the solicitors, they use internal mail with windowed envelopes, which I will then prove to you later. None of it's been recorded. None of it's gone through postal mechanics. So how can they prove that I've received anything? The only way they can reprove if I answer back, which I did honourably, as you can see, by giving my remedy. Again, notice of default and opportunity to cure to Santander solicitors. Again, no reply back. All the replies back I've had from Santander are, please pay an alleged debt through a contract that I have allegedly signed. And as you can see through all my evidence, I've offered to pay this alleged contract on proof of the original contract. And we shall see later that the evidence that they bring is a copy. And under law, they have to prove the original contract. Under law. Right. Again, I shall show these later, but again, to the solicitors of sending affidavits and notices for them to do in honour. All Santander has done is just repeated themselves, stating that one minute they don't have the original, and then next minute they've sent original copy. A copy is a copy. It needs to stand on law. And I would then show you the law, what's required through case law. And all they've done is statement of account. Statement of account does not prove there's a contract in place or that there's loss of money. It needs to be shown through the ledger and the consideration. In April and December, multiple affidavits served unrebutted, DSAR requests submitted with non-complete disclosure and fraudulent enforcement action observed. Right. These are my affidavits. As you can see, there's a receipt that's gone through postal mechanics. It's been paid for. I've paid to make sure that this company received my affidavit of truth and statement of fact. They received this, but not replied. I shall give you a little rundown of what the affidavit is requiring. So an affidavit entered into a contract with Santander for a credit loan facility. Affidavit believes no contract evidence of an alleged contract exists and no timely rebuttal is affirmed. affidavit receives, and the affiant receives a credit and loan shortly after the affidavit and contract was done. Affidavit believes no contrary evidence exists and no timely rebuttal has been affirmed. These are all here. There is 30 questions that they needed to rebut. Each question needed to be rebutted. And to this day, they've not answered one. Another affidavit. Affidavit of conditional objections of notices of non-consent has been sent. I resent the original affidavit. I've also sent an affidavit of truth and final commercial notice of claim and recoupment through commercial law. Again, not been replied back, nor have been rebutted. An affidavit of truth on an original document. Additional reference for strengthening, so affirms necessity of full honest disclosure of contracts, highlights the importance of complying with strictly statutory requirements in financial agreements. These are case laws, which I also should read later. So under statutory references, they are actually now acting under the Fraud Act of 2006, Section 3, failing to disclose information where there is legal duty to do so constitutes fraud by admission. And GDPR Article 5 requires organisations to demonstrate compliance with lawful data request. Maxim in laws, he who's not rebutted is agreed. They have not rebutted. 1, 2, 3, 4, 5. Affidavit of truth, equity and lien recoupment. 6. Affidavit of truth. 7. Affidavit, that's the original from the original document. And that one is as well. 8 affidavits, all standing truth in law, not been rebutted. I consequently sent DSARs, data search access requests, that we are all entitled to do to corporations when they hold our personal data. I shan't bore you with the details. 1, 2, 3. Notice, by the way, they've all been sent postal mechanics. They've been received and signed for. So they've had these. 4, 5, 6, 7, 8, 9, 10 to the solicitors as well as the bank. 10. That's it there. 10. Firstly, over the last 2.5 years, that's one every 3 to 4 months. Not rebutted, not adhered to. I've replied to the ICO. They admitted that they didn't reply to them. They offered me £100 for the inconvenience. I've got that letter here, if anyone needs to see that. And that they will adhere to the DSAR that I've requested. And all they've sent is numerous of letters and statements of account. Nothing more. Not answering the DSAR as they're entitled to and they should do under their obligation as a legislated commercial enterprise. Again, February of 2024, I started my liens. You have to bear with me where my liens are. I'm sure I've done that. Okay, just to let you know, these are, they were the communications to the solicitors. So if you just bear with me. Oh, I'll tell you what, are these more? Let's put that up there. Okay, ready to go. Okay, so also I've sent them liens because they're not honouring. They've totally ignored me. They already took me to their legislative corporate court where they ignored my conditional acceptance, ignored my remedy, ignored my standing under the UCC 1-308 as all rights reserved, as a man under natural common law. They totally ignored everything and put a charge. They stole my car. They arrested me at 1:30 in the morning and I was in the cells for 24 hours. Ended up with no charge. By that time they'd stolen my car. And still to this day, they're still chasing me for an alleged outstanding. And I will show you the charge order from this alleged judge. And I say an alleged judge, and they sit there in their ivory towers as judges, because they're not. They're out of their jurisdiction. They swore an oath to the bar, and that's where their loyalties lie, not to the people. And the bar is registered into the inner city of London, which is a foreign state. They step out of that foreign state and they become anybody just like you and me on the presumption of a judge. You need to challenge that presumption because they are not a judge as in fact in law. They are, I suppose you could call it an imposter, because they are an imposter, because they have no jurisdiction, rights, or even under their oath, because that's all stated into the state of a foreign state and not in England. And therefore, that's why you say when you get these warrants, recovery orders, whatever you want to call them, are not signed by them, because they have no authority to sign it. And if they do, then they become liable. This is why they don't sign it. They're not insured or assured. They're not bonded because they can't be, because they're out their jurisdictions and they're not acting under their oath. So they cannot be assured. This is why they don't give you their bonds. So the commercial liens were sent not only to the King's Bench, to Santander, to the solicitors, and to certain judges who unlawfully made these orders and carried on pretending that it was in a lawful court. I've DSAR'd the MOJ on numerous occasions for the transcript, for my summons, and for the recovery order. And to this day, they do not have it. So what does that say? So as you see here, this is a law court we're having here. We're entitled to this, every man and woman entitled to this law court, because it's open and transparent and it's there for the public record, and it will be put out to the public and you will see this. Unlike their courts, these are legislated corporate courts, hidden, so they're not being held accountable. One lien, conditional acceptance and notice of liability, ignored. Final notice, 24 hours demand payment for cure, ignored. Commercial lien, ignored. High Courts of Justice actually wrote back politely and says you need to go somewhere else and do a judicial review. Judicial reviews takes into their jurisdictions of the corporate entities. That we do not want to do because it's been compromised. High Courts of Justice have received prerogative writs. Writs are the highest standing order that you can send to all judges, to corporations and solicitors to act on an obligation when you send a prerogative writ. Prerogative writ. Ignored a notice of default regarding that prerogative writ. They are not following their own legislated rules. A prerogative writ of mandamus, again, sent to the district judge, to the solicitor, to the CEO of Santander, to the Right Honourable Dame Sharp, OBE of the King's Bench, High Division, or ignored. All been sent, recorded delivery, paid for, and they've been received and signed for, as evidence shows. Again, writs. Again, an affidavit was sent. Affidavit in the nature of a writ, truth, status, and lawful standing. Not replied back, not rebutted either. Each one, a notice of dishonour and administrative estoppel to stop them, they ignored. Everything's done above board and transparent and gone and recorded. It's again, everything's... The list is endless of what they're doing and not doing. Evidence is all here. This has all been sent to them, to the courts, to the banks, and to the solicitors, and to the Ministry of Defence. Ministry of Justice. So they've all received this, and it's still here now for them to receive and see it for the truth and facts and law. So, January to May of this year, the refusal of prerogative writs by Judge Perperel forced unlawful administration hearing, issuing recovery orders without signature and seal. Again, I shall show you there of what they class as an order. And in May 2025, I sent out an arbitration invitation both to the bank, to the solicitors, and to the judges. To Santander, Mike Rayner, the CEO. To the solicitors, Jay Gibb and Sir Nigel Graham Knowles. To the Right Honourable Dame Victoria Sharp of the King's Bench Division. And the District Judge Lubiga of the Ministry of Justice. Invited them, as you can see, again, gone through postal mechanics, signed and paid for and received. Invited them to this arbitration court, just like they invite us to their courts. But this court is recorded and transparent into the general public. Maybe that's why they didn't want to come. Who knows? We only can presume like they do. One arbitration invitation. Two arbitrations invitation. And a third, the power of three. On each occasion, they've ignored. And as I stated at the beginning of this court hearing, I've stated what we stand under. And just before I finish, I just want to just state some case laws. Now, we have to be careful when we state case laws, because people state case laws and they stand under it. You don't want to stand under case laws. Case laws has been done through a judge. So there's common law precedents and there's common law natural law. That's where we stay. But we have every right to call out these case laws because they are obligated to act under them. Whereas the sovereign men and women, we're not. Okay? We don't go into their jurisdictions. We stand as natural law. Original contract and holder in due cause, as I mentioned before. Carey versus HSBC, Bank PLC. A lender must produce a true and original signed agreement when requested. If unable to do so, enforcement may be paused. Carpenter versus Logan. When a note and a mortgage have been separated, both null and void. This applies to the alleged debt and has been securitised. Fairness of due process. Not only must justice be done, it must also be seen to be done. This addresses the impartiality concerns raised by a judge calling you or calling me by the wrong name and not engaging with my conditional acceptance. I have numerous of ones I shall go through. R versus Clark and McDade. Recovery orders and warrants must be signed to be legally enforceable. An unsigned recovery order violates procedural justice. On the King's Bench, judgment clarifies unsigned recovery orders and warrants are invalid. And even under the CPR, Civil Procedure Rules 40.2, all warrants and recovery orders must be stamped and signed. They ignore this. And when you call them out, they try and take it out to a different direction. And the last one, Lazarus Estates Limited versus Beasley, 1956. Fraud unravels everything. A fraudulent recovery order or misrepresentation voids the contract and related orders. Thank you. I shall show you these at the end, the recovery orders, unless you want me to see them now. In fact, let me just show you quick ones of now, and then I will yield. Just bear with me, guys. I think I've got them here. Right, here we go. Just these few here. This is an application they're trying to put onto a charge, so that's not actually a recovery order. So I'll just put that one to one side for the moment. Okay, this is a photocopy of a general form of judgment order. A stamp is not a sealed, embossed stamp. Anyone can get that. It needs to be a proper court official stamp. No signature. No signature whatsoever.
Pass it down.
Would you? Yeah. Again, judgment order for goods. Notice the boxes. And in law, and especially in legislative sides, they have to adhere to their legislations being corporate entities. Anything in the box isn't on the paper. The four-corner rule. 1 box, 2, 3, 4 boxes, 5 boxes, 6 boxes. Again, they call me by a legal fiction name, which I've stated on numerous occasions that that's not me. And then again, no signature. Yeah, that's just a copy of that. What I want to do is just show you. Right, I'll show you 2 of these copies. This is a photocopy of a supposedly that allegedly order that the judge done. You'd think photocopies will be exactly the same, wouldn't you? Just look and compare it to that last one, Gary, that you received. In fact, here you go. I'll just show you. Can you point out the differences in the same recovery order? Can you see any differences?
Yeah, the name.
A name in the box.
In the box, yeah.
Whose does that one there?
DWF Law.
That's the law. It's not the name in there, is it?
No.
It's supposed to be the same order. If you look at the stamp,
Yeah.
the stamp's not in the right place. What are these courts doing? Or what are the banks doing? We know what they're doing. I should also show you some more evidence of fraudulent paperwork. That's the same, that one is there, what you've just seen. So there you can see the difference between the orders. Now they should be exactly the same. There's something amiss there that needs to be investigated. And when I pull these up and call them up, they ignore it. Right. And thank you for your time to listening to my, I suppose, my issues. Thank you. Statement. Statement of truth. Yes.
Can you put both documents in front of the camera?
That's a good point. Yes.
Yeah, and then we'll edit this bit out.
Yeah,
So as you can see on the camera,
The stamps, stamps in a different place, and the name is different. Okay, that's exactly the same order, the same date, same recovery order. 18th of July, what is going on? This is why we need these courts, because they won't allow this in their courts, because we know that then we've proven them fraudulently and corrupt. Thank you. I yield.
I had Terry Males, a neutral third-party arbitrator, acknowledge this arbitration is convened under the rightful authority of natural law, common law, and just in rem jurisdiction, where all commercial agents are held accountable under the corporate mandates and bonds. Having reviewed all the unrebutted affidavits, liens, evidence of non-disclosure, fraudulent procedure, and unlawful enforcement proceedings undertaken by the aforementioned entities, I hereby determine in law and equity that the claimant, Darren Watt of the House Smith, stands as rightful executor and creditor. Santander Consumer UK plc and agents thereof, along with administrative judiciary officers, are in default by dishonour. Claimant's perfected lien is validated and enforceable in full, including costs, damages and punitive interest.
I, Gary of the family of Mauds, clerk to this lawful arbitration court, affirm that all documents, evidence and filings have been examined and recorded, confirm lawful service. No rebuttal or response in law has been filed within any reasonable time frame. All procedural timelines have been met. All defaulting parties served per lawful process.
We, the undersigned witnesses, have been present during this lawful arbitration. Affirm, under penalty of perjury and full commercial liability. We have observed full presentation of evidence by the claimant. No counterclaims, verified rebuttals, or lawful jurisdiction claims were present by the opposing parties. None turned up. We confirm the authenticity of the proceedings under the law of the land.
Thank you. Thank you. Kenny? Thank you.
Next witness, Terry.
Okay. We, the undersigned witnesses, having been present during this lawful arbitration, affirm under penalty of perjury and full commercial liability. We have observed full presentation of evidence by the claimant. No counterclaims, verified rebuttals, or lawful jurisdictional claims were presented by the opposing parties. We confirm the authenticity of the proceedings under the law of the land.
Thank you.
As arbitrator, I declare that Santander Consumer UK plc and affiliated entities owe £5 million commercial lien damages in the equivalent of gold, silver or Turon, £2.5 million judiciary malfeasance damages in the equivalent of gold, silver or Turon, £2.5 million administrative and solicited damages in the equivalent of gold, silver or Turon. Accrued punitive damages calculated at £250 per day since the 15th of February 2024. Final commercial enforcement rights are granted to the claimant under, including but not limited to, enforcement via private debt collection agencies, enforcement via commercial third-party securities collection, reporting to international debt recovery bodies, lawful publication and disclosure of global human rights organisations. Final enforcement and recovery order. This judgment of this arbitration court, established under common law, UCC and UBC, is binding under international contractual law and is hereby declared final. Full commercial recovery order issued this day, the 15th of August 2025. Enforceable immediately without further notice.
Thank you. And I'd just like to say before we finish here, the jurisdiction, again, that this is under, it's lawful, it's transparent, and every man and woman are entitled to have this arbitration court when justice is not being done in the legislative corporate courts. These proceedings is recognised under common law authority, the Constitution of Magna Carta 1215, United Nations Declarations of Rights of Indigenous People, UNIDRIP 2007, just in rem jurisdiction, Universal Commercial Code, Uniform Bonding Code, and General Principles of Equity. All parties notified by this lawful delivery, public notice will be posted. Thank you. There are now statements and recovery orders that need to be signed, so this signs and seals today's proceedings of the matter. Thank you. So if we can come up, please, witnesses, arbitrators, arbitrator, and the clerk, please. So we've got the witnesses there. So that's one for you, and then to Kenny to sign. If I sign you there in blue.